We're on the record in docket 23-01003. That's people of the state of Michigan versus Christopher Smith. Will the parties please introduce themselves for the record?
Jeff Flores on behalf of the people, Your Honor.
Good morning, Your Honor. John Abbott representing Christopher Smith. He's appearing by video from the jail.
All right. And sir, you are Christopher Smith?
Yes, sir.
Is that from the Fed Polycom
No, it's the jail
tablet? All right. Can you say your name again, Mr. Smith?
Christopher Smith.
All right, thank you. This is the time set for a probable cause conference. Mr. Brodowitz, how are we proceeding?
Mr. Smith will be waiving the preliminary exam.
All right. And that's your understanding, Mr. Brodowitz?
Yes, Your Honor.
Mr. Abbott?
Yes.
And so it's an unconditional waiver?
Yes.
Yes, Your Honor.
All right. And negotiations are to continue in circuit court?
Yes.
Yes, Your Honor.
Mr. Abbott, may I inquire of Mr. Smith of his waiver?
Yes.
All right. You understand, Mr. Smith, that you have the right to a preliminary examination within 21 days of your date of arraignment. Do you understand that, sir?
Yes, sir.
And a preliminary examination is a probable cause hearing in which the prosecutor would have to prove by probable cause evidence that a crime was committed and the identity of the person who committed that crime. Do you understand that?
Yes.
You, of course, are represented by Public Defender John Abbott, and he would be present to cross-examine any witnesses and contest any charges brought against you. Do you understand that, sir?
Yes, Your Honor.
If you waive your right to a preliminary examination, you'll be bound over to circuit court on the charges in the complaint and warrant. And right now, it is an unconditional waiver and negotiations are to continue. Is that your understanding, sir?
Yes, Your Honor.
Is it your wish today to waive your right to a preliminary examination?
Yes, Your Honor.
Okay, I find the waiver to be freely, understandably, and voluntarily made. I've indicated the unconditional waiver for the record. Does the people also waive their right to a preliminary examination?
Yes, we do, Your Honor.
All right, I'll accept the waiver and bind this case over to circuit court. Sir, your next date will come from your attorney, John Abbott, all right? Sir, your time in district court is done and you're now in circuit court, all right?
Yes, sir.
All right. Anything else for the record in file 23-01003, Mr. Brodowitz?
Nothing from the people, Your Honor.
Mr. Abbott?
Nothing from the defense. Thank you.
Thank you. Then do you have to sign something? All right. So you're all set, Mr. Smith.
I don't like it.
And Mr. Abbott, do you have O'Reilly too?
Yes. She's in the hall. I'll get her.
All right.
Right.
Oh, how you doing? Sorry.
Right, so we're on the record in docket 22-02303 and 22-03192. That's people of the state of Michigan versus Courtney O'Reilly. Will the parties please introduce themselves for the record?
Andrew Stevens, on behalf of people.
Good morning, Your Honor. John Abbott representing Courtney O'Reilly. She is present and standing to my right.
Ma'am, you are Courtney O'Reilly? All right, thank you. This is the time set for a review hearing. Mr. Stevens, how are we proceeding
Your
today?
Honor, it's my understanding that the parties, unless Mr. Abbott will correct me, the people have not received anything new regarding the forensic evaluation. And based on my review of the ROA, this was scheduled as sort of a tickler to make sure we don't forget about Ms. O'Reilly's case. And so I know the court usually receives correspondence, so unless the court has received something updated, but with that, I'll defer to Mr. Abbott.
All right, Mr. Abbott.
I think that's an accurate description of the situation, Your Honor. Ms. O'Reilly continues on the right path. We're hoping that she'll stay on and still anticipating a response in the forensics.
All right, do we have any date or anything from the forensic center at this time? Right. Right. I mean, my notes are indicated that this was a control date, just so we didn't lose track of the file in regards to, it's my understanding that Ms. O'Reilly, she was seeking mental health treatment on her own.
Yes, I actually got some documentation for the counseling services I'm receiving at Michigan Recovery
Perfect.
Services, community mental health.
And that was just as a gap filler until the forensic evaluation's done.
Yeah, yes.
Yes. So that's my understanding. The only reason we set this is to make sure that we're keeping track of the case. Are we looking out for, I mean, like another 60-day control date or something like that?
Okay.
That seems appropriate.
Yeah, I mean, I'm fearful that I don't want this case to fall through the cracks in any way. And I want to keep an eye on it. So let's set a control date in 2 months. So we'll set it for June 8th at 8:30.
Oh, is there any way that I could get it scheduled a week later, because I think I have a vacation that's gonna be the first.
I don't have any problem with that. Do you?
Fine.
Okay,
Thank you.
so we'll do it 1 week later.
Thank you so much.
So it'll be June 15th.
Yeah, that's, thank you. Your Honor.
Okay, June 6th. Let's do it on June 16th. Okay.
Yeah, thank you.
Yep. June 16th. So Ms. O'Reilly, keep doing what you're doing, okay? Whatever you're doing is working, and I'm glad you brought your documentation today for Mr. Abbott to see. We're gonna set it for June 16th, and we'll just wait to hear from the Forensic Center on this. Anything else for the record on either one of these cases? Docket 22-03192 or 22-02303. Mr. Stevens.
Nothing from the people.
Mr. Abbott?
Yes, Your Honor, she just mentioned that she's going to Florida in June. I request the court's permission for her to leave the state of Michigan.
So do you have any objection to, I would assume that under both of these, it's no out-of-state trial. And you actually heard better than I did. Is that a vacation, Ms. O'Reilly, or is that?
Yes, but it's not completely set in stone, so I can get in contact to make sure.
Once you know exactly what dates you are, contact Mr. Abbott or your pretrial services so that we can make that accommodation, okay? Mr. Stevens?
The only thing I was going to say is just upon verification of dates, the people will defer to the court.
All right, thank you. So yeah, once you get your date sets, let us know, all right, Ms. O'Reilly? All right, thank you. That's all for the record in 22-02303 and 22-03192.
Thank you.
Thank you, Mr. Abbott.
I would guess which day this is.
All right. Wait a second. the red light, forget
Figure out
everything.
who this guy is. That's
No, I
all.
understand. Yeah, I already talked to
Which
her
one,
about it.
Mr.
I've already, well, sent an email.
Sir, on the Zoom, on this phone, BW40DL, would you identify yourself?
Lewis Hill.
What's your name?
Lewis Hill.
Lewis Hill.
Lewis Hill. All right, Mr. Hill, you're here for your 8:30?
Yes. Yes.
All right. Stand by, you're in the right place, all right, sir?
Okay. Thank you. Okay. Thank
So, Mr. Hill, we're gonna put you in a breakout room with your public defender, Mr. Milks, okay, sir?
Okay. Okay.
All right.
They make me bound for the circuit court.
Think she would be a good candidate for probation.
So, Mr. Callwriter, we'll call your case as soon as we find the prosecutor on the case, okay?
Okay, that's fine, Your Honor. Thank you.
All right. And then, Mr. White, you're here on
Justin Gallegos.
Gallegos. All right.
Yeah.
That one's gonna be a wait.
All right. Is that one of yours or is that?
That's one of ours.
Oh. But is
Your
that
Honor, could
yours
I-
or is
Your Honor-
yeah, just okay? Is your client present? Okay, I see Mr. Gallegos. All right, when you're ready, Mr. Brodowitz, we can put that on the record. Okay.
Your Honor,
So we'll call that case up next, Mr. White.
okay, if I can have a couple minutes with him in the
Absolutely.
breakout room.
Right. So I'm going to have Mr. White and his client, Mr. Gallegos, placed in a breakout room.
Thank you, Your Honor.
Thank you. Now we can.
Dale, can you hear me?
I can.
I see you're on Zoom. Where are you physically at in this building?
I am in the jury room down by Judge Buchanan's court.
Wanted to talk to him?
Yeah, I'm gonna come right now and meet you on Stephen Austin. We gotta talk.
Okay, we're on Zoom, so I'm here.
Yep. I'm gonna.
Cookies, I can't hear now. Case. Case.
No, not yet. Have you seen your attorney or anything? I've seen my attorney, but already, you're just waiting on the judge? I'm waiting on the prosecutor, actually. Okay.
All right, Mr. White, we're ready on Gallegos if you're ready.
Ready, Your Honor. Thank you.
All right. So we're on the record in docket.
What's the name of the facility?
We're on the record in docket 23-00933. Will the parties please introduce themselves for the record?
Jeff Brodowitz on behalf of the people, Your Honor.
Sanford.
Go ahead, Mr. White.
Oh, thank you. Yeah, Toby White Law. We're here on behalf of Justin Gallegos. He is joining us by Zoom. We appreciate the court's accommodating that. He is over at the Sanford Health Center at a rehabilitation center. It's a inpatient treatment that he's undergoing there.
All right. And sir, you are Justin Gallegos.
Yes, Your Honor.
All right. And you are joining us from the Sanford Addiction Treatment Center?
Yes.
All right. This is the time set for a preliminary examination today. Mr. Brodowitz, how are we proceeding?
Yes, Your Honor. At this time, after speaking with defense counsel and based on conversations at the probable cause conference, I believe today the parties, after speaking with the defense, the parties have agreed to unconditionally waive the right to hold a preliminary exam. And the people would ask that this matter be bound over to circuit court as charged in the complaint.
And is that your understanding, Mr. White?
It is, Your Honor, and you are free to inquire of my client.
Thank you. Mr. Gallegos, and I know we met last week, and so this was kind of set in the works, but I'm going to read you through. So you understand what the lawyers have indicated concerning this preliminary examination, sir?
Yes.
And you understand that you have a right to a preliminary examination, and a preliminary examination is a probable cause hearing in which probable cause must be proved by the people of the state of Michigan that a felony was committed and that you committed that felony. Do you understand that, sir?
Yes, Your Honor.
You, of course, are represented by attorney Toby White, and he would be present to cross-examine any witnesses and contest any charges brought by the people against you. Do you understand that, sir?
Yes, Your Honor.
If the court accepts this bind over to circuit court on the charges in the complaint and warrant, you'll waive your right to a preliminary examination, and it will be bound over as an unconditional waiver, negotiations to continue in circuit court. Is that your understanding, sir?
Yes.
You today wish to waive your right to a preliminary examination.
Yes.
Okay. Your waiver is done freely, understandingly, and voluntarily made. I've indicated the plea agreement for the record. Mr. Brodowitz, do you waive your right to a preliminary examination?
Yes, people do, Your Honor.
All right. So I'll accept the waiver and bind over the case to circuit court on the information filed. Mr. Gallegos, you'll get your next date from attorney Toby White in circuit court. Your time in district court is done today. Okay, sir?
Okay. Thank you. Thank you, Your Honor.
All right. Anything else for the record? Oh, and we do have that. I'll just let the PA 53s go with the case.
No objection, respectfully, Your Honor.
So any objection, Mr. White, to just having the PA 53s follow the case?
No, Your Honor.
All right. Anything else for the record, Mr. Brodowitz?
Nothing from the people, Your Honor.
Anything else, Mr. White?
Nothing further. Thank you, Your Honor.
All right, Mr. Gallegos, your time in district court is done. Here, you're now in circuit court, so get any future dates from Mr. White in circuit court. All right, sir?
Okay. Thank you, Your Honor.
All right. Thank you, Mr. Gallegos. Good luck to you. We're all set on that file. Okay, so Hill is on.
Right, she is.
Right. All right. We don't need to put that on the record, do we?
That's what we usually do. Ask more as they think.
Right. Mr. Milks, did you want to put Hill on the record or?
I didn't.
All right.
I didn't need to. I didn't.
All right. I'm just going to tell him we're leaving it on.
That's perfect.
That's
Yes.
Mr. Hill, you can unmute yourself if you have any questions. All right, can you hear me, Mr. Hill?
Yes, sir. Yes, sir.
All right, we're leaving, so your probable cause conference, the lawyers have met, we're just leaving it on for preliminary examination today on April 14th, 2023 at 8:30, okay, sir?
Yes, yes.
All right, if you have any questions, contact your lawyer, Mr. Milks, in this regard. That April 14th at 8:30, that's live in person on the 6th floor, okay, sir?
Okay, okay, thank you.
All right. So you're all set. You can leave the Zoom courtroom.
Thank you.
Mr.
I think we're ready for Stephen Austin.
All right. Mr. Hill.
Excuse me, Your Honor.
Sir, what is your name on Christian's NA21?
Jesse Lincoln, sir.
Your name is
Jesse Lincoln.
Jesse Lincoln.
Yes, sir.
Right. You probably should speak. So go ahead and stand by. Your attorney is John Abbott. Is that correct?
Yes, sir.
All right. So stand by and you can mute yourself because we're going to have a hearing right now.
Yes, sir.
Mr. Colwriter's here on Mr. Austin. So, Mr. Colwriter, are you ready on Mr. Austin?
I think we are, Your Honor. Thank you.
So we're on the record in docket 23-00379. That's people of the state of Michigan versus Stephen A. Austin. Will the parties please introduce themselves for the record?
Yes, good morning, Your Honor. Assistant Prosecuting Attorney Adam Pfeiffer on behalf of the people.
Thank you, Your Honor. Dale Coltrader, appearing on behalf of Mr. Austin, also on behalf of the Public Defender's Office.
And sir, you are Stephen Austin?
Yes, sir. Yes, Your Honor.
All right. This is the time set for a probable cause conference. Mr. Pfeiffer, how are we proceeding?
Your Honor, there are 3 different issues. It's been a very busy 24 hours for this case. The first is the case of the same victim I signed in October. The second is the meth possession case that my office signed this morning. And the third are the jail calls the defendant has made to the victim. So first, this case involves the victim of James Collins for an incident in the evening of October 5th, 2022. That's the charged offense we're here for today. I signed a separate complaint involving the same victim, James Collins, the same defendant, Stephen Austin, occurring on the same day, 6 hours earlier. The victim had actually just come back from the hospital from that incident when he was attacked again. He is currently charged one. Now, I signed off on that warrant on 10/20/2022 for counts of assault by strangulation, assault with a dangerous weapon, and domestic violence. I realized this morning that for whatever reason, even though I signed it, it does not appear that be in the system. I have my warrant unit checking down right now as to whether it was sworn to at all or it just never got, it fell through the cracks and never made it before the court.
All right.
I've seen it to where that's happened. I've also seen it to where judges sworn off in it, but it never got entered into the system.
All right.
So that is a significant concern because these 2 events, 2 criminal cases, are pretty unavoidably intertwined with each other. The other matter is that my office, literally as of this morning, just signed a felony warrant for possession of meth for this defendant. And I see on the emails I'm getting that is being brought over to be sworn to as soon as possible. So that's going to be either today or potentially Monday. As a result of these matters, I think an adjournment is appropriate. I don't believe a lengthy one is necessary, because what I don't want to have happen is that takes forever, and then this case just gets held in limbo. But I do think a week or 2 week adjournment is appropriate for the matter.
All right, thank you. Mr. Colrider, these are brand new to you, I would assume.
They were just introduced to me this morning, Your Honor, and also the allegation of phone calls to the jail.
All right, so I would think that is good cause in and of itself to adjourn the preliminary examination. We have a pending earlier that day complaint. We have a pending possession of meth that is a 10-year complaint, and then we may have PA 53 violations.
Yes.
All right, so I think that's good cause to adjourn the date. Did you want to maybe see where this lies? Maybe adjourn the PCC to the prelim date and then set a new prelim?
I think that would actually work out rather well.
So let's do that. Let's do,
PCC on the 14th.
yeah,
Next
yeah,
Friday?
yeah.
Okay.
So so I find there's good cause to adjourn based on the two pending the pending domestic assault and the pending meth, and then the PA 53 violation should all be considered here. I find that's good cause to adjourn this PCC, and we'll reset the PCC for April 14th.
Reset the PCC.
Yeah, for April 14th.
If they're issued today,
We're effectively treating the exam as a PCC.
Yeah, we're just exactly. So it gives you some time. Yeah, but it at least gives you some time to talk about the charges.
And also to make sure that it's actually getting taken care of, and that he's
gonna
not
leave
just
that
sitting-
between your office and, you know.
Okay, I just wanted to let you know that today starts a different exam cycle.
And then the preliminary examination will be set for 1 to 2 weeks after that.
20th. I didn't know if you wanted it set now or to wait till the other cases caught up.
Let's go ahead and set it now, and then
We'll
we'll
set it for the 20th at 8:30.
at 8:30. And that way, the attorneys, everybody knows what's coming now, so there can be discussions on that. Mr. Austin, you understand, Mr. Colrider may inquire of your client concerning these dates?
Yes.
You understand that the probable cause conference has been reset for April 14th, 2023 at 8:30, and the preliminary examination has been reset for April 20th of 2023. There's some pending cases here that Mr. Colrider can talk to you about. All right, sir?
Yes, you are.
All right. And I find this is a good cause, the pending 2 issuances and the PA 53 are good cause to adjourn. So you're not waiving any of 21-day right or anything along those lines. Anything else for the record, Mr. Pfeiffer?
Oh, yeah, the people would like his phone privileges revoked.
Okay.
He's called the victim 2 times from lockup, 4 times from the new jail. He actually called him yesterday at 2 p.m. from his own account, 2 phone numbers listed in each report. And at one point even left him a voicemail saying he's in jail and he's gonna lose everything.
And this is brand new to you, Mr. Colrider,
I can't speak today,
Right.
I haven't heard the phone calls. I know
All right.
nothing about it.
Well, until we hear, based on Mr. Pfeiffer's representations, that there is a violation concerning contact with Mr. Collins through phone, I am going to deny any phone privileges to Mr. Austin.
Just to be clear, I would ask that he retain his e-messages only because I see that he has at least started correspondence with the CAPS program, and I wouldn't want to.
All right. And then retain any email privileges?
Yeah, the only e-messages I see involve cats, and
All
that's
right.
something that can be helpful for him. I wouldn't want to get in the way of him being able to be a part of that program.
Okay, so I'm denying phone privileges concerning Mr. Austin. I'll allow retain email privileges. And I'm sure Mr. Colrider's told you, Mr. Austin, that your phone calls are being monitored and your emails are being monitored. So you understand that, sir?
Yes, sir.
All right. Anything else for the record in docket 2300379? Mr. Pfeiffer.
Nothing from the people, Your Honor.
Mr. Callwriter?
No, Your Honor, I think this takes the wind down
Oh.
my sails a little bit today.
All right, you're all set today. You're free to leave, Mr. Austin.
Thank you, Your Honor.
Thank you. And that is Lincoln. So, Mr. Alvarado. What's that?
Mr. Lincoln is saying he's supposed to be here, Mr. Abbott.
Right.
But Mr. Alvarado.
So Lincoln is on Kristen 821, correct?
I was not there.
Yeah, you weren't here. That's why I was telling you that Lincoln is on 821. But I'm not sure. We didn't do anything on that case yet, right?
No, Mr. Abbott. Held that.
So we're on the record in docket 23-00194. That is people of the state of Michigan versus Robert Alvarado. Will the parties please introduce themselves for the record?
Jeff Brodowitz on behalf of the people, Your Honor.
And good morning, Your Honor. Stephen Milks on behalf of Mr. Alvarado, who is present and standing to my right.
Sir, you are Robert Alvarado?
Yes, sir.
All right, thank you. This is the time is set for the preliminary examination. Mr. Brodowitz, how are we proceeding?
Yes, Your Honor. After speaking with defense counsel, I believe the parties have come to an agreement at this time to unconditionally waive our rights to hold a preliminary examination, and the people would ask that this be bound over as charged in the complaint to circuit court.
Is that your understanding, Mr. Milks, with negotiations to continue?
That is correct, Your Honor, with negotiations to continue with an eye towards potential treatment options.
All right. Mr. Milks, may I inquire of your client of his preliminary examination?
Yes, sir. Thank you.
Of his waiver. All right. So you heard the attorney speak today? All right. And you understand that the prosecutor and both the prosecutor and defendant have a right to preliminary examination today. And a preliminary examination is a probable cause hearing, which the people would have to prove by probable cause evidence that a crime has been committed and the identity of the person who committed that crime. Do you understand that? You, of course, are represented by Mr. Milks from the Public Defender's Office, and he would be present to cross-examine any charges and contest any charges or witnesses brought against you by the people. Do you understand that? If you waive your right to a preliminary examination, you'll be bound over to circuit court on the charges, the complaint and warrant, and you would waive your right to a prelim. Right now, as you heard the attorney speak, it's an unconditional waiver with negotiations to continue. Is that your understanding?
Yes, sir.
Is it your wish today to waive your right to a preliminary examination? Mr. Brodowitz, do you waive your right to a preliminary examination?
Yes, we do, Your Honor.
Okay, I find the waiver to be freely, understandingly, and voluntarily given. We've talked about negotiations to continue in this unconditional waiver. I'm going to accept the waiver and bind over to circuit court on complaint. Circuit court. And so you will receive any future dates from Mr. Milks, okay, in circuit court. Your time in district court is finished. All right, sir? All right. You can have them sign that. I don't know if there's a place for Mr. Brodowitz or not. So that's all for the record in that in docket 23-00194. Ready now, Mr. Smith?
I believe so, Your Honor.
Go ahead and come up here, Mr. Smith. So we're on the record in docket 23-00898. This is people of the state of Michigan versus Derek Smith. Will the parties please introduce themselves for the record?
Jeff Brodowitz on behalf of the people, Your Honor.
And good morning, Your Honor. Stephen Milks on behalf of Mr. Smith, who is present and standing to my right at this time.
And sir, you are Derek Smith?
Yes, sir.
All right, thank you. This is the time set for preliminary examination. Mr. Brodowitz, how are we proceeding?
Yes, as you stated, Your Honor, today is the date and time set for a preliminary examination. This matter was set at 8:30. The people have subpoenaed witnesses. I have called the hallway in the courtroom, and unfortunately, only one of the witnesses the people had subpoenaed has appeared. And at this time, people would be unable to proceed based on the witnesses that have appeared. So I believe the defense would have a motion.
All right, motion by defense.
Thank you, Your Honor. Your Honor, as today is the date and time for the preliminary examination, the defense is ready to proceed, but the people are not. We do ask that the court dismiss the case against Mr. Smith.
All right, thank you. Based on the people's inability to proceed at the preliminary examination, the case is dismissed without prejudice based on the defendant's motion. So you understand that without prejudice means that the people could reissue if they choose to, but on this date, at this time, this case is dismissed, all right? All right. Anything further? And yeah, Mr. Milks, if you can grab that nollie that we just printed, I'll sign it.
Oh.
Usually Nathaniel does, but.
He's slacking, apparently.
Well,
or taking someone downstairs.
You're double duty.
Yeah.
Now you are the prosecutor. Now you are the prosecutor and the court officer.
That's fair.
So I'm going to sign the dismissal based on the motion. Anything else for the record, docket 23-00898, Mr. Brodowitz?
Nothing from the people, Your Honor.
Mr. Milks?
No, sir, thank you.
All right, thank you. Mr. Smith, you're all set. Thank you for your appearance today. How are you? Mr. Brodowitz, I'm not sure if Ms. Minor is represented today.
I do not believe she is.
All right.
And that was, I don't know if Mr. Goodrich is here, if someone's covering for him again.
I don't know.
I was going to address the case. I know they're set at different times, but I was going to address the case against Ms. Minor and Ms. Horn, and the cases against Ms. Horn at the same time, being as they are co-defendants in one of the matters.
Okay, so Horn and so Minor and Horn are co-defendants.
Yes, and there is a third co-defendant in that one, Your Honor, where I know the arrest warrant has, I believe on Tuesday, it was finally signed.
All right.
So there will be a third co-defendant that entering into.
All right, so let's wait for Mr. Goodrich to show up and we'll do those together.
Ms. Minor is not the
I believe we may be ready on how, Your Honor, but give me just 1 second.
All right.
Mr. Goodrich is in the hall.
All right.
I don't know his name.
She is. She's in the courtroom.
I don't have. It may have been signed. Not Yeah.
Then Mr. Lincoln.
I just. Mr. Abbott called for him. I did send Mr. Abbott an email.
Okay.
He was on-
Well, we'll tell Mr. Abbott when he comes. He probably wants to meet with Mr. Lincoln.
Not council conference, just one email.
Mr. Abbott is busy.
I think he's actually.
We'll put it on the record.
Yeah. He would have been given what she should have. She can't have a copy of the warrant.
If she's representing herself. But that means that all discoveries released to the defendant will make note of it on the record. No, she gets but she's got to say on the record, I'm representing myself. She gets anything that it comes to me.
Yeah. It's almost worse than not appearing.
Mr. Abbott, Mr. Lincoln is on Zoom if you'd like to speak with Mr. Lincoln.
Guess.
Right. I don't know. He's your client, so he is here and he's on Zoom. And if you were looking for him, that's where you can find him.
Thank you.
Did you want to talk to him?
Yeah, I guess I better.
All right. So, Mr. Lincoln, you can unmute.
Yes, sir.
Mr. Lincoln, I'm going to place you in a breakout room with your public defender, Mr. Abbott, okay?
Yes, sir.
All right, as soon as he joins the Zoom courtroom, I'm going to place you in a breakout room with him, all right?
All right.
All right, this was the time set for preliminary examination, which is live, but you've chosen to join us by Zoom, so I'm going to go ahead and place you in a breakout room with him, all right?
Oh, yes, sir. I apologize, Your Honor.
Mr. Lincoln, you're gonna have to join the breakout room. You should get a prompt, or you should hit on your Zoom to join room 1.
Okay,
So go to breakout rooms and join room 1.
I don't see anything on here for it.
Mr. Abbott. Yeah.
Yeah.
Get one now?
Yes, because I think he's frozen. Now you can move Mr. Abbott to, yeah, there you go.
Mr. Abbott.
There we All right, so we're on the record in docket 23-00609. That's people of the state of Michigan versus Jesse Lincoln. Will the parties please introduce themselves for the record?
Jeff Brodowitz on behalf of the people, Your Honor.
Good morning, Your Honor. John Abbott representing Jesse Lincoln. He's appearing today on video.
And sir, you are Jesse Lincoln,
Yes, sir.
and you can hear me all right, Mr. Lincoln?
Yes, sir.
All right, this is the time set for a preliminary examination today. Mr. Brodowitz, how are we proceeding today? Before we start, Mr. Lincoln, you need to come to LPD and get your fingerprints done, all right?
Okay.
Yeah, I have an order for fingerprints that I've signed indicating that you should come in. For whatever reason, that wasn't done at your initial arraignment, and therefore it has to be done regardless of what happens with the case. All right, sir?
Yes, sir.
All right. With that understanding, Mr. Brodowitz, how are we proceeding today on the preliminary examination?
I guess at this point, Your Honor, as you stated, today is the date and time set for preliminary examination. The defendant was ordered to be here in person. Defendant has not appeared in person. And so the people would ask that a bench warrant be issued and bond be forfeited.
Okay, thank you. Mr. Abbott, your response?
Your Honor, thank you. And I appreciate the fact that the witnesses for the people have been sitting here patiently for about 2 hours. Yeah, however, my client is not here. Apparently he misunderstood the directive to be here in person, Your Honor. And he is staying in contact with the court, and we're requesting that this be adjourned and rescheduled to a date when we can come back and do it in person.
All right. Is it your intent? Well, this set is set for prelim on April 6th. Is it your intent that I can find good cause, but is your client willing to waive his right to a prelim within 21 days?
Yes.
All right. So, Mr. Lincoln, you by appearing by Zoom, you violated that we were supposed to be here live, but you did appear today, and I'll take that in consideration. It's my understanding that you're requesting that through your attorney, Mr. Abbott, you waive your right to a preliminary examination within that 21-day period. Is that your understanding, sir?
Yes, sir.
You have a right to a prelim within 21 days of your date of arraignment. That preliminary examination is a probable cause hearing, which the people would have to prove by probable cause evidence that a crime has been committed and that the identity of the person who committed that crime. You have the right to have Mr. Abbott present to contest any charges and cross-examine any witnesses brought in your defense. Do you understand that, sir?
Yes, sir.
That's what we're going to do at today's date. Is it your wish today to waive your right to a preliminary examination within that 21-day period?
Yes, sir.
Okay, I'm going to find the waiver of the 21-day to be knowing, voluntarily, and accurately made. I'm going to reset this preliminary examination.
Your Honor, before a date is set, if I may, Mr. Lincoln is scheduled to be arraigned out in 55th in Mason on a possession of methamphetamine charge on April 11th, 2023. He's also got charges related to this incident that are out in 55th and in Eaton County. And in part of our discussions with the defense, we've talked about the potential for a global resolution of all these charges. So I would just ask that the new preliminary examination date be set after that April 11th date when he is arraigned in 55th. So that we can kind of get everything on the same page.
Just so all the files are together.
Yes.
Yeah. So I have no objection to April. Do you need, in order to look at all the files, and I know that Mr. Brodowitz wants to stay in contact with his victim on a UNP case. Do you need some time to get all the files together? So are we talking 3 weeks, 2 weeks, a month? What do you think, Mr. Brodowitz?
I mean, I guess I'm not sure exactly how long after arraignment PCCs are generally set.
Generally, probably within 21 days. Yeah.
Okay. Generally, I think it's within a week. So I would say
So about
Probably
3 weeks?
April, yeah, April 18th at the earliest.
So sometime around April 18th that week. Or just so they can get all the files together. Doesn't make any sense to set this for prelim and not have it. April 20th. 20th at 8:30. Bond will be set on the other matters by the arraigning judges. Mr. Brodowitz, your witnesses were here today.
Yes.
And you'll stay in contact with them. If we don't need to have them here, I mean, that's up to you, because since there are other pending charges coming.
Yes, Your Honor.
All right. Anything else for the record? Docket 23-00609, Mr. Brodowitz?
Nothing from the people.
Anything, Mr. Abbott? All right, Mr. Abbott, you're all set. How about Ms. Johnson? Mr. Lincoln, you're all set. Please keep in contact with your attorney, Mr. Abbott. All right, sir?
We're ready to go on, Jackson.
All right, you're free to leave the Zoom courtroom. Johnson. She's here.
We're ready.
All right, so we're on the record in docket 23-00925. It's people of the state of Michigan versus Caroline Johnson.
Can I have just 1 minute, Your Honor? before
Sure.
we go on, so I can
Sure, yeah.
Witnesses go and then,
Is this going to be a prelim or is it going to be?
I believe we're, yeah.
All right,
So that's
so go ahead and meet with your witnesses. We'll come back and we'll do a prelim on this.
Okay, so
I can.
I'll be here for lunch.
Yeah. Yeah,
So we're not calling this case?
I mean, we can
Just call it.
it's. I guess- I would prefer to wait.
All right.
And then-
Why was that April 20th?
It wasn't, I.
Yeah, I know.
None of the cases.
I think we're off the record, right, Your Honor?
They know about that. I mean,
That's why I gave you that.
We are off the record, right, on that?
yeah, we are off the record.
Your Honor, oh my God, oh my God, yeah. I didn't know. Oh, my God. Mm.
You were only using one hand.
I don't remember. All I know is she had a hammer up in the air and threatened me, and
Okay.
that's the way it
And
is.
she was holding it like this.
One hand or two hands, one of them. I'm not sure which. I don't
Okay.
remember.
She didn't hit you with it?
No,
And you got up and left?
like almost immediately.
Okay. And what time of day was this?
It was late.
Is it light out or dark out?
It was dark.
Okay.
It was late. 10, 11, 12. I don't, it might even been later. I don't know.
And you remember what she was wearing?
No, no. I see her every day, so I don't really know.
Okay. And so Ed, are you still living at that address?
I am.
And all right, so I guess just to be clear, so you actually were afraid you were going to be hit, or you weren't afraid?
At first, I was not.
Yeah.
After a couple seconds, I felt like she really was going to do it. That's why I left. If I wouldn't have been afraid, I wouldn't have left.
And you waited until after she put the hammer on the bed?
Yeah, I didn't wait. That's just when it happened. She said, if you go to sleep, you won't wake up. A couple seconds later, brought the hammer down. I heard it hit the bed, so I hit the bed. Just within a few minutes after that, I got up, threw my clothes on the left.
Okay, so by the time you left, the hammer was already on the bed?
Oh yeah, that was past that.
And whatever risk there had been was gone?
I don't know. I left, so I don't have to worry about it.
Right, but she was not in a position at that point to hit you with a hammer.
When I left, the hammer was already gone out of her hand.
Okay. So how many seconds do you think you were worried about being hit?
Maybe only a minute, maybe 2 minutes.
So you
just that fast, I realized I thought that I was in danger. I said I had to get out of here.
Okay, so you're saying that she held that hammer over you for 2 minutes?
I didn't say that.
Oh, well,
I said afterwards. After the hammer hit down, within a minute or two, I was convinced I was in danger and I was going to leave while I got a chance to leave. The hammer's out of her hand. I'm out of here.
Okay, so the hammer was out of her hand for about 2 minutes and then you left?
That's probably close to correct. Yes, sir.
Okay, so you stayed there for 2 minutes?
Maybe a minute or two, but that's not a very long time.
No.
I had to get my head together, figure out where I'm going to go at night. I don't have nobody.
Right, but you weren't dodging out of the way of the hammer?
No, we were already past all that.
Yeah.
But I did the right thing. I left.
Yes. And you succeeded in achieving the goal that you set for yourself in that text message?
Now that's kind of leading me along because that was not meant at all. That was something I said to him. And there's no way in the world I ever would have thought that she was going to go to jail as a PP or whatever that thing is called. Never entered me for one moment. I just don't want to fight. That's all I want to do. No fight. I'm getting away, so there's no fight. I think I did what I was supposed to do.
Okay, so that never occurred to you?
Ask the question again.
So you sent a text that day that said you needed to figure out a way to get away from her.
Yes.
And then later that day.
This incident had absolutely zero to do with that.
Argumentative.
I think he's answering the question, so.
It had
I'll
nothing
overrule
to
the
do with that,
objection.
Your Honor. It just so happened, I sent that text, she busted me with it, and that expedited it evidently because now she can't live there, but it wasn't my intention.
No.
Never, not for a moment did I ever think that.
Not at all. Okay, thank you. Nothing further. Your Honor.
All right, redirect, Mr. Rodowitz.
No further questions, Your Honor.
All right, may this witness be excused from the people?
Yes, Your Honor.
Defense?
Yes.
All right, sir, you're excused from your subpoena, okay?
I don't like doing it.
All right, you're free to leave, the stand, sir.
Yeah, I just, instead of putting them to do that. Okay.
Do you need some time to talk to your client or?
No,
All right,
no, we were just going to, people would call Officer Morgan Schaefer.
all right. Officer Schaefer, you can stand right up here. Right here, stop. Please state your name and spell your last name for the record.
Officer Morgan Schaefer, Morgan
And you-
Schaefer.
Okay, please raise your right hand. Do you solemnly swear affirm, tell the truth, whole truth, and nothing but the truth under penalty of perjury?
I do.
All right, have a seat here and please project for recording purposes.
Thank you.
Mr. Brodowitz, when you're ready.
All right. Good morning, Officer Schaefer.
Good morning.
Officer Schaefer, how are you employed?
I am a police officer at the Lansing Police Department,
And how long have you been a police officer with Lansing Police Department?
almost 5 years.
And were you working in that capacity on, or I should say, in March of 2023?
Yes, I was.
Okay. And I guess on that date, how were you dressed? Were you on duty were you on duty on the date of March 20th, 2023?
Yes, I was.
Okay, and how were you dressed that day?
In a fully marked police uniform.
Okay, and was there any point in time during that day when your duties took you to the address of 509 Baker Street?
Yes, I was.
Okay, and why were you called to that address?
In reference to an assault.
Okay, and during when you were called there for the assault, who did you make contact with?
I made contact with the victim that day, Michael Weir.
Okay, and what I guess what did Mr. Weir tell you happened that day?
He stated he was having a verbal argument with his fiance, whom he had been with for about 4 years.
All right, and is what did Mr. Weir say happened in? So he said he was having a verbal argument. Did he say anything else happened?
Yeah, he said he was in the bedroom of the 500 Baker residence, and his fiance, Mrs. Johnson, had a sledgehammer at one point and threatened him with it.
Okay, and how did he say she threatened him with it?
He demonstrated to me that Ms. Johnson had a sledgehammer and was holding it at ear level next to her head.
Okay, and then is that everything, or did she use the sledge in some way? What did he tell you happened after that?
He stated that she made a lunging movement toward him in an attempt to make him think that she was gonna hit him with it.
Okay, and then how did he explain how that made him feel in that moment, or?
His demeanor when I met with him, he was crying and stating he was in disbelief and upset over the incident.
Okay. And then after, I guess after he described her making the lunging motion with the sledgehammer, what did he describe after that?
He described that she threw the sledgehammer down onto the bed about 6 inches away from where he was laying.
And then what did he do after? What did he tell you he did after that?
He stated that he left the residence, began walking to a nearby convenience store where he called police and then waited for police contact.
Okay. And then did you have occasion to interview the accused on that date and time?
Yes, I did. After my interview took place with the victim, Mr. Weir, myself and another officer then made contact at the 509 Baker address where we met with Ms. Johnson.
All right. And then do you see Ms. Johnson in the courtroom today?
Yes, I did.
Can you indicate to the court where she's sitting and an article of clothing she's wearing?
Ms. Johnson is sitting to my left wearing a green hoop.
Okay, let the record reflect that the witness has identified the defendant.
Without objection, Mr. Abbott, for preliminary examination purposes.
objection.
All right, the witness has identified the defendant.
No other questions at this time, Your Honor.
Any cross-examination, Mr. Abbott?
Thank you. Good morning. Thinking back on your interview with Mr. Weir, he's describing how she was holding the hammer. Can you show me what he was doing when he said that? Did he hold?
Yeah, he demonstrated to me that it was head level, ear level, and a striking motion.
He had it with like one hand like this?
Yeah, that's what he stated to me.
Okay.
So let the record reflect, the counsel has indicated one hand above is on the right side of his body, and so the witness has agreed.
And did you ever find a sledgehammer?
Yes, I did locate a sledgehammer inside the residence in the bedroom.
Did you? You know how much weight? Did you pick it up?
I did pick it up. I collected it and turned it into our evidence room.
So somewhere there's a sledgehammer in evidence,
That's correct.
even though it's not here today. You don't see it here today. do you?
Because I haven't reviewed the entire room, but no, I don't see it.
Okay. Was it a heavy hammer?
Sledgehammer is, I don't know how to put a weight limit on it.
Okay, thanks. Nothing further, Your Honor.
Any redirect, Mr. Brodowitz?
Just briefly, Your Honor. Okay, Officer Schaefer, can you describe the sledgehammer that you recovered at the scene?
Yeah, the sledgehammer was metal and silver, and then it had a handle which was red and black.
Okay, and was this a full-size sledgehammer, or more, I guess, what people would describe as, I guess, a hand sledge?
I mean, size variation of all.
About how long were you, just for the record, how long were you indicating the sledgehammer was?
Maybe a foot and a half.
Okay, no further questions, Your Honor.
Any cross based on the questions, Mr. Abbott?
Oh, thank you.
May this witness be excused from the people?
Yes, Your Honor.
Mr. Abbott?
Yes.
All right, you're excused, ma'am. Thank you. Any further witnesses, Mr. Brodowitz?
Nothing from the people, Your Honor.
Right. Did the people rest?
We do at this time.
Any witnesses from defense?
Not today, Your Honor.
All right. Motion for bind over, Mr. Brodowitz.
Yes, Your Honor. The people would ask that this court bind this matter over as charged in the complaint. As we heard from Mr. Weir, this incident took place in the city of Lansing, at 509 Baker Street, which is in the city of Lansing, which is in Ingham County. Mr. Weir also identified the defendant as Miss Carolyn Johnson. As for the crimes of assault with a dangerous weapon, Mr. Weir testified that Miss Johnson held a sledgehammer over her shoulder in a striking motion, which caused him to fear that she was actually going to strike him. And as we know, the definition of an assault and a battery does not actually need to happen. It just needs to put someone in fear that the battery will take place. Mr. Weir did state that he was afraid that Miss Johnson was going to strike him with a sledgehammer. However, Mr. Weir also did say that he did not believe, well, he was not sure what her intent was with said sledgehammer. As to count 2, domestic violence, again, Mr. Weir testified that Miss Johnson held the sledgehammer over her shoulder in a striking motion in an assaultive fashion, and that they were in a dating relationship for 4 years. We also heard testimony from Officer Schaefer, who stated that this incident took place on March 20th of 2023. With that, one second. With that, and then we also heard testimony from Officer Schaefer that corroborated what Mr. Weir testified to on the stand, that Miss Johnson held the sledgehammer over her shoulder in a striking motion in reference to, or in close relation to Mr. Weir, causing Mr. Weir distress and to to fear being struck with said sledgehammer. So with that, Your Honor, the people would ask this court to bind this complaint over to the circuit court as charged.
Response, Mr. Abbott.
Thank you, Your Honor. My recollection of the testimony is, Your Honor, that was that the defendant held the sledgehammer, either one-handed or two-handed, depending on which version of the story you're thinking about, and said something to the effect that she might hit him, at which time he said he didn't really think she was going to do it. And she set the sledgehammer down on the bed, and he waited around a minute to 2 minutes, and then he got up and left. It's our position, Your Honor, that if you actually believed someone was about to hit you with a sledgehammer, you would jump out of bed immediately and get away from them. You wouldn't lay around for a minute or two and then decide to run away. So I realize this creates a question of fact, I suppose, but I'll leave it at the court's discretion.
Thank you. The standard for preliminary examination is probable cause. Therefore, the court has found by probable cause evidence that the date of March 20th, 2023, identification of Carolyn Johnson was made in court as the person who's accused of the crime. The venue is the city of Lansing, Ingham County, and the location is 509 Baker Street in the city of Lansing, Ingham County. There are some issues of facts concerning credibility of the witness, but of witness Mike. So I base my decision based on the testimony of Michael Weir and Morgan Schaefer, the two witnesses who testified. The indication was that there are some of course issues of fact that can be recognized concerning the testimony, but that the witness indicated, Mr. Michael Weir indicated that Carolyn Johnson raised a sledgehammer to the side of her in a motion like a bat. There's no indication of the intent to do it that time, but he did say on more than one, on at least two occasions, I think she meant to put me in fear, and I was eventually put in fear. He did said he was not in fear at the first part of it, but he said that, I think he used the words, the look in her eye would indicate that he decided that he should leave the premise, and he decided that Ms. Johnson was using that as a dangerous weapon. I find by probable cause evidence that the defendant did make an assault, an offense of touching or placing the victim or the complaining victim in reasonable fear. Michael Weir with a dangerous weapon, a sledgehammer that's been indicated by both witnesses, but without intending to commit the crime of murder, inflict great bodily harm less than the crime of murder. That's so I find that with that at a probable cause level, which is the only standard for the preliminary examination purpose, that by probable cause the defendant has committed the crime. The second count of the misdemeanor count will follow the felony count, and I will bind over on both counts to circuit court, where the defendant will get their next court date in circuit court on the felony. So I find by probable cause evidence that count 1 and count 2, especially count 1, the felony has been committed. I bind the case over to circuit court. Ma'am, you'll get your next date from Mr. Abbott, your attorney in circuit court. Your time here in district court is done. The case is bound over to circuit court. Anything else for the record in docket 23-00925, Mr. Brodowitz?
Nothing from the people, Your Honor.
Anything, Mr. Abbott?
Yes, Your Honor. All of the defendant's possessions are at the location of 509 Baker Street. Your Honor, we did request that she be given the opportunity to recover the personal belongings, the telephones and her clothing.
All right. I would see at arraignment that was did not seem to be addressed. So I will indicate that the defendant may, with law enforcement presence, go to the address. Our acronym for that is MAGO. May go to get all their personal belongings. To get all personal belongings. Of course, the victim will be notified and should not be present, or it would be a good idea not to be present. Belongings. But you can go there one time with law enforcement to get your belongings, and that will not violate the no contact order. Okay.
I have evidence on my phone of photos in my gallery, and
some of my passwords have been changed since the 20th.
I don't, just get what you need and then get there so there's no misunderstanding about the no contact order. Okay, ma'am.
Yes.
All right. Anything else? So I would allow the victim to go one time to the residence, get her personal belongings with law enforcement. Anything else for the record, Mr. Abbott?
Well, thank you.
All right. Okay, that's all for the record. Docket 23-00925. Ms. Johnson, you're next. It'll be in circuit court. Please keep in contact with your attorney, Mr. Abbott, okay? All right, thank you.
This is outrageously crazy.
Ms. Sutter?
Hello.
Good afternoon, Ms. Sutter. Thank you for joining us. The judge will be in just a moment and your client is in the courtroom in person.
Thank you. Would it be at all, I don't know if the courtroom has an iPad or not, would it be at all possible to talk with him?
If Nathaniel pops up anytime soon, sure.
Okay,
I
thank
don't
you.
know where A, the iPad is, or B, those things are not supposed to touch.
All right, okay, thank you.
Yep, let me see. Nathaniel just ran downstairs, so let me see if I can find him. Just a second.
Thanks.
Okay, Miss Sutter, I'm gonna try this.
Thanks.
Miss Sutter, I'm just gonna leave him in here and I'll leave the room, okay?
Okay, that sounds good. Thank you.
Except for I don't know how to make this thing connect to the audio.
Haha, you're seeing what they go through. If you find that little microphone button down in the lower left corner.
I think I hear it.
I think I got it. I have a very large computer, Miss Sutter. Oh, should I just turn the iPad off and have him talk to you in here?
If you're gonna leave the room, I that's probably fine.
Let's do that. The iPad doesn't have much power.
Okay.
You scoot that way, she can see you just fine, sir. Give me 2 seconds before you start talking to walk out of the room, okay?
Well, actually, Wendy, before
Bye.
you leave, I see that the Zoom is live right now on YouTube.
Yeah, YouTube.
Am I famous? I got some license ethical obligations to follow here.
Yes, you are correct. All better.
Thank you.
Thank you. All right, don't talk yet. I find my keys yet. Okay, Miss Sutter, he's all yours.
Okay, and you're sure it's not live streaming, Wendy? It still says live on the Zoom, on my Zoom.
I took us off of everything.
Okay.
I canceled Zoom.
Is there a setting on the Zoom to stop the live stream? Because it still says there it's zooming, and I'd rather be more overly cautious than less.
Just a second.
Thanks.
Well, there's nobody else in the room. I can tell you that, so nobody else could hear you.
Right, but my license obligations, I cannot allow a recorded conversation of a privileged communication.
I'm working on it.
Thanks.